Uh, Good afternoon, everyone. Welcome to the BHBA Startup Law Initiative Recap. I'm LaVonne Lawson. I practice tax law, and it is my pleasure to act as a moderator for this program. Here are a few comments before I introduce the speakers. The BHBA Startup Law Initiative currently includes a set of 8 courses and differs a little from our regular programming in that it is geared toward entrepreneurs and business owners. Our speakers today will provide their set of takeaways from the first 4 programs we had, which involve the following topics: fundamentals of getting started, selection and organization of the business entity, protecting IP, and employment. Those were held early this year and can be found at the BHBA's on-demand programming, as well as at the BHBA's YouTube page. Materials from those programs, as well as for today, you can find also in the chat. We are in the process of scheduling the next set of programs, which will be on the following topics: incentive plans for employees, tax planning and compliance for startups, initial funding, raising funds in the cap table, and exit strategies. So we'll send out save the date notices for those soon. Finally, questions are of course welcome. Now on to our speakers. I cannot say enough about them, so I'll just say a little for now. Thomas Gaffney has grown a strong practice advising entrepreneurs at all stages of business, especially startups and emerging growth companies. He has become respected as an expert in the Web3 space. At the firm Olsen Brueggemann, Thomas is a transactional team lead and specializes in startup financing, corporate organization structuring, private equity fund formation, and cryptocurrency regulations. Layton Pace is an experienced corporate and tax attorney with a practice focusing on federal and California taxation and transactions involving LLCs, corporations, and individuals engaged in a variety of business and real estate related activities. Layton is a frequent speaker and writes on a number of tax related topics. He was previously active with taxation section executive committees, the State Bar and LA County Bar, and Layton currently serves with the BHBA Taxation Sections Executive Committee. Jonathan Menkes is a partner with the Knobbe Martens firm, where he provides strategic trademark counseling and brand protection for clients across numerous industries, which range from NFTs and blockchain to fashion. Jonathan's practice includes domestic and foreign trademark selection and searches, trademark audits, unfair competition, false advertising, and notice and takedown procedures involving copyright and trademark claims on social media and domestic and foreign e-commerce websites. Last but not least, Jeffrey Bils represents employees in wage and hour class actions, PAGA representative actions, and in their individual cases. Before this, Jeff spent several years representing employers, but also in an interesting background, he began practicing law only after spending 15 plus years as a news journalist with papers including the Chicago Tribune and Fresno Beat. Jeff serves on the BHBA's Board of Governors, as well as on the Labor and Employment Section Executive Committee. Well, those are our speakers, and with that, I'm going to turn this over to Layton to start talking about the business plan.
Thank you so much. I appreciate being part of this. We had a 2-hour presentation in May on choice of entity issues. So I please encourage you to go look at our materials. They're much more detailed than what we're going to talk about today. But our presentation started on factors affecting the choice of entity, which to me is really the factors in a business plan. Those are like, what's the nature of the business to be conducted? What are going to be the assets? How many people are going to own the business? How's it going to be funded? And I think most importantly, what's going to happen on exit? What's the home run ball? How do you expect to get out of this if everything goes well? And I think at the same time, you figure out if it doesn't go well, what are going to be the consequences, and how do I set myself up to maybe benefit from that too? I think we concluded that if you're talking about entrepreneurial startup, that currently with venture capitalists, that a Delaware C corporation has to be seriously looked at as being probably the primary entity to use, but an LLC has many benefits as well. So I'll pass it back to you.
Okay, wonderful. All right, so those were conclusions. And when you start thinking about it, Thomas, what are the things that we should be thinking about as we're kind of getting started in this venture?
Getting started in a venture? Well, there's a lot to think about, right? And one thing that I would stress towards, that I always stress towards my clients is picking the correct team, right? You have to have people on your team who are founders when you're actually getting into this, right? When you want to start a venture, when you want to start a business, yes, choice of entity, very important. But at the same time, you also have to choose an appropriate team to work with, right? Everyone's going to have an appropriate skill that they bring to the table. Everyone has to kind of be able to collaborate together in an appropriate fashion. And everyone has to be on the same page to kind of move forward, I think, in the right direction so that you can even get on the same page to start talking about and working with these things. As a startup, I specialize in advising startups. And the one thing that I see when most businesses fail, it isn't because of the idea they have, it isn't because of the talent they have, it's because the founders don't work well together. They start arguing over equity, they start arguing over who does what and what happens. And if you take time to sit down, pick a team correctly, and choose your teammates and your founders correctly, then that can pay dividends so much in the long term. And so what I always do, and because most people like get together and they start being friends, and they want to do this business venture, but I start trying to set some expectations and be like, hey, make sure that everyone has a very defined role in what they're doing, so that everyone can work together in a collaborative form so that you can move the business forward. And that's one of the most important things that I always kind of put a stamp on when someone talks to me first about, hey, Thomas, why don't you set up my business? I'm like, all right, well, what advice do you have? Pick a good team. Pick a good team and have a good idea and just keep moving forward.
Okay, excellent, excellent. So when did they start thinking about coming to you and coming to Layton, and which should be worried about, even in terms of, Layton, we made certain determinations or kind of where, what sort of entities we might like, but then also there's implications, employment implications, IP implications. So I want to get to those, but when should they be thinking about, when do they start coming to you and to Layton?
Sure, I'll take it first, and I'll let Layton take on because he's the choice of entity expert. But yeah, so when most people start coming to me is when it's either two or three fashions, right? One, they have this great idea and they're like, I want to talk to these people. Should I have an NDA to start talking to people, right? And it's just like, well, let's start moving down the road a little bit. Let's start getting something real. And like I said, start getting part of a team. And then one of the other fashions is they are kind of have banded together, had this idea and are started working. And then it's like, okay, well, then we can start talking about choice of entity. We can start talking about whatever. Or it's when they are post revenue, where they're actually starting to bring in money. And then all of a sudden they'll say they're a boutique handbag designer, and they're going to these shows and they're starting to sell these handbag designers. And all of a sudden they want to, they're getting some revenue coming in. They start wanting to protect themselves, start thinking about tax consequences, start thinking about how they could potentially take advantage of having a business entity. And then those are the times when people really start talking to me. And that's when we can get started in the nitty gritty. And I'll let Layton take it over from there.
Yeah, I think advice at an early stage is always good. Money is always a factor. People don't want to spend a lot of money on something that really hasn't come together. I really do agree that getting a good team together, business people as well as professionals, is important. But again, it's always about money. How much do we put forward? Money's always short starting off, and people generally want to get services or products underway first. At least an idea, it's a viable idea before they start putting other things around it. But I would generally say sooner is better than later for getting advice, because people do things without realizing that there are other complications.
Well, have I started to infringe, Jonathan? In my handbag example, what am I facing on the IP side? I've gotten started, I'm bringing in money, I'm selling these handbags like crazy.
Which is a good problem to have, and I wish all of my entrepreneurs have that success problem. I agree with everything that's been said so far. I think seeking counsel early is typically better than trying to fix something later. And for me, one thing that I hope people take away from the conversation we had last time is that the brand name is important. Hopefully it's not a descriptive one. It's a strong mark, as we talked about. And it's one that hopefully there's a domain name available to support that, but I wouldn't go about it where you have your handbags, you pick a name because you picked the domain name to match it. And now it turns out, hey, there's actually a big problem because there's some other company you didn't know of who has that name first. So as mentioned, going to counsel early to have that conversation. What is the trademark at issue? Some sort of clearance search. It doesn't have to be a full-blown deep dive analysis. Frankly, just looking at the USPTO database and using your favorite search engine is a great way to start and just see what's out there before you really start picking up momentum, because the last thing you want is to have that momentum and then you have to notify all your customers and potential consumers that, hey, I actually have to change the name for these wonderful handbags. So I think that's what I would say there is it's worth consulting early on just to get a sense of how strong is my trademark, are there things I should do now as far as filing, and look at the big picture. Even if money's a little bit tight, planning ahead is always a good idea.
Okay, excellent, excellent. So Jeff, you're on the employment side. I've got all these workers. What do I do now?
Well, for a startup, as an initial matter, just as Jonathan mentioned, that it's a good idea to get IP counsel on board early, it's a really good idea to get employment counsel on board early, because there are so many potential pitfalls in the employment laws that that not everyone is going to be aware of, or that someone starting a business might have the wrong idea about going into it without realizing what they're doing. So it's really important. I think it really is a good way to preserve the value of what you're building by starting it correctly from the outset. One of the what I do now, I do plaintiff side employment actions, mostly wage and hour class actions, and they're expensive. And they're also preventable as long as you are implementing good wage and hour practices at the beginning, taking into account things like meal and rest periods, overtime, classification of employees, whether to treat someone as an employee or as an independent contractor. All of these issues really need to be nailed down, and if to the extent that a business is casual about it, they're setting themselves up for potential problems. So another really important thing to look at too is whether you want to invest in employment practices liability insurance, EPLI. A lot of startups may not be familiar with that kind of product, but it offers some peace of mind if you run into an employment issue as a business. But without getting too much into the weeds, just a highlight of some of the issues that you need to be mindful of in addition to wage and hour. There are harassment prevention measures that businesses need to be aware of, especially in this climate. When you start bringing people in, when you start talking to them, even at the interview stage, you have to be really mindful about how to ask questions, what really should not be asked. And then once people are in the workplace, how do they interact with each other? How do they interact with clients outside of the office? And there are some requirements too as to policies that sometimes will go into an employee handbook, which are set forth in regulations that California has promulgated. You've got paid sick leave. There's just a whole range of really crucial employment issues that any kind of startup, any kind of business really would do well to confer with employment counsel about at the early stages.
You know, Jeff, you've described a lot of things to think about. And I mean, is the initial decision going to be basically how you classify the worker? And are you finding that people in California have they all gotten the message with AB5, or are they still wanting to, just kind of keep it casual, treat people as contractors and hope for the best?
Well, I think especially for newer businesses, I don't know if it's widely understood how much of a pitfall it can be to misclassify an employee. So I think that there, often on both sides, a person may ask to be treated as an independent contractor for whatever reason. and the employer might think, great, let's do it, without realizing that it may not be proper for that particular situation. So, I mean, there has been recent changes in the law in this area in California. We now have this ABC test that you were referring to, which is a test when you consider whether a worker is an employee or an independent contractor, and it has to do with just generally 3 conditions that have to be satisfied. The worker needs to be free from the control and direction of the hiring entity in connection with how the work is performed, both under the contract and also the way they actually do the work. Second, the worker needs to perform work that's outside of the usual course of the hiring entity's business. That's a big deal. So if you're hiring someone who's doing basically the same business that you operate, that person is likely not going to be able to be an independent contractor. And the third is the worker is customarily engaged as an independently established trade, occupation, or business of the same nature as that involved in the work performed. So if these are not all met, the business is opening itself up to potential employment claims. Because I don't know if that gets to the question that you were asking, LaVonne, but I think the answer is that there are still a lot of, especially newer businesses or smaller businesses that may not really be aware of the requirements or may not really understand the consequences of failing to meet them.
No, that's exactly what my question was. It just seems that if kind of getting that first decision wrong can have huge consequences going forward, employment, tax, and so forth. Did anyone else have any thoughts about that?
One thing I wanted to briefly mention in the vein of employment considerations is for copyrights, which they could be photographs. If you think of a website, the text that goes on a website, the logos, things of that nature. If you have an employee who, as Jeff talked about, some of the factors to look at, who is designing that for you, it's their job description to prepare those materials, then it's likely that the company owns the copyright, which is great. Then the company can file the copyright application with the office, and everything is good, so to speak. However, if there's some dispute about that or disagreement or uncertainty, you'd want to watch out for that. Typically, the way that copyrights work is that whoever takes the photograph, writes the text, whoever is doing that activity is considered an author and they own it. And what that means is if you have an independent contractor, whether it's someone you hire on a temporary basis or you hire a graphic designer to create your website, they own the copyright to that. And I definitely would not rely on these what I would call boilerplate agreements by certain companies. You really need to have an attorney who's experienced to look at them. I think at least 9 times out of 10 when my clients tell me, oh, don't worry about it, Jonathan, I already have the copyright assignment, I say, okay, that's great. Send it over just so I can double check. And when I double check, 9 times out of 10, there's some defect there that they're not actually getting the rights that they thought. They're getting a license, and you don't want a license as the company. You want to have full ownership. So just rounding out the discussion on the employee piece of it, it's important to know who is creating the content for IP, and that would dictate who should be filing it and whether any assignments need to be prepared.
Wow, thank you, because that's an interesting tension. Thomas, you were.
I'd like to ask a follow-up question to Jonathan on that. So what you just stated is something that I run into continuously with my clients. So I have a lot of clients that pull people from Fiverr or even just from Twitter, posting an ad or some type of angel website, social media, whatever, where they find these people with their description of work for hire, like a type of contract worker. Can you explain a little bit about how the implications go on that side? Because it's something, I'm not an IP specialist, right? And so a lot of times I'm like, yeah, well, we'd have to look into it further. I'm not exactly sure. So if you can explain a little bit on that, kind of how like the business, like say like Fiverr, like those kind of specific platforms that work and connect you with different contractors, that'd be great.
Perfect. And I haven't worked with them specifically, but other if I've had clients where they outsource graphic design for the website, and I don't want to name any names, but they'll send me the logo to register, and I look at it and I say, okay, can we talk about the assignment agreement? I'll look at it, and again, it'll have a defect where it'll refer to IP generally. It won't call out the copyright. It won't describe what the logo is. Sometimes you have a situation, I had this happen a few years ago, where the person who actually created it was in India for this company, and there's no way to track them down. And that puts you in a really scary situation, because technically they have copyright rights in it if you didn't get a proper assignment. And so you can prepare them relatively easily. They're not overly complicated. I would advise against just finding whatever's on the internet. Seek certainly sound advice of counsel, but what you want is, if there's any doubt as to who owns the copyright, just get the copyright assignment from whoever you're working with. Hopefully it's an amicable relationship. Larger companies, you'd expect that they would have sufficient language, but not always. And so it's worth looking at, checking to make sure that you're getting, what are you getting? Is it an actual assignment versus a license? This comes up a lot in NFTs, frankly. We could probably talk about this for hours. But the problem with NFTs, as some recent litigation with the Bored Apes Yacht Club shows, is that if it's this open nature where, oh, go ahead, I'm transferring all my rights to you as the creator of this NFT. I retain no ownership. Well, what happens when that NFT falls into the wrong hands, or someone makes a copy of that? Now you have no recourse for going after them. So that's why agreements and clear language are so important.
Thank you. That's very helpful. We've got a couple questions, so I'm going to jump into them and throw it out to the group here. And I'm not taking these in particular order. One of the questions is, does California presume work for hire, or does work for hire provision have to be expressed in the employment contract?
So work for hire, that's more of an IP type of concept, I believe, Jonathan.
So the situation, it's very, unfortunately, fact specific, but if just looking at it, if you've got the director of marketing and they are preparing the website material, I keep going back to that since that's probably the most common situation I deal with, then there is, in a sense, a presumption that, okay, that you don't need to prove it to the Copyright Office. That would really come up if someone were to challenge it, to say, the employee, I guess, if they left and said, hey, wait a second, I wasn't within the scope of my employment, or I own the rights to the photograph that I took for this company, or the text that I wrote. So in that sense, it's sort of presumed, but I guess I want to just be clear that it's fact specific. So if you've got an employee situation that's within the scope of employment, likely the company owns it. If there's any doubt in your employee handbook, you could have them sign something that's part of that. And I'm sure we could have a whole discussion on just employee handbooks and what to include there. But hopefully that answers that question. If not, I'm happy to dig in further.
Yeah, and I mean, what I've seen is that employment agreements will very often, where it's appropriate, spell out specifically what these provisions are as to the intellectual property. So the new employee will disclose what it is that they have an interest in, and then there will be some agreement entered into as to how it will work. And those types of agreements, whether it's an employment agreement or some kind of contract agreement, it's worthwhile, obviously, having employment counsel look at them too. If you're not trying to create an employment relationship, there's always the potential that you might inadvertently do so if you include some of this language in an agreement with someone who's supposed to be a contractor. So that's a case where you might want to have both your IP counsel and your employment counsel take a look at that kind of agreement.
Thank you. No, I appreciate both of your responses there. I've got a couple more questions here. One is more IP focused. I'll go with that first. And then the next one is kind of a broader, kind of just a more existential question, certainly, or in terms of the life cycle of the company. With respect to kind of the IP, one question is, if I trademark a logo and travel out of the country and someone else claims ownership of my logo, what steps should be taken? Some of these may be very specific, some may not. If if we can answer them here, great. If people want to follow up with particular speakers, they have your info and the materials as well. So
terrific. Great question. So the rule of trademarks is this: it's the first to use in commerce, a name, a logo, maybe it's both. Nike's "Just Do It," it's a slogan. So whoever uses that first in commerce in connection with some product or service, whether it's shoes, apparel, purses, legal services, consulting, that's who has the trademark. And so where you are located has no bearing as far as if your company's in California, you travel to Taiwan on business. It's not like the trademark travels with you or otherwise. It's wherever you've been using it, that inures to your benefit. Certainly that if you're doing business in multiple countries, and that's something around 50% of my practice is spent outside of the US, protecting brands globally. If you've got operations in China, Taiwan, the Philippines, it's worthwhile to get a trademark, at least consider getting a trademark registration there, because unlike the US, which is a first to use country, most countries outside of the US are first to file. And what you'll see is that you file at the trademark office, and within a few months, you could go on a number of registries, especially in Asia, and there will be squatters, people who are watching the USPTO registry and going off to China, Taiwan, the Philippines, what have you, and filing your trademark to prevent you from getting it registered there. And that's a problem if successful, because the mechanisms through which you can challenge that are pretty complicated. But thankfully, the US has a treaty with pretty much every country that I would imagine people would file a trademark in, such that if within 6 months, you file in the US today, if within 6 months you file in China, in Taiwan, wherever else, those countries have to acknowledge that it's as though you filed there today, even if you waited 4 or 5 months. So you backdate it to today. So that gets rid of, or at least mitigates, the pirate issue where you file in the US and you worry about someone running off to another country and squatting on your trademark and asking for millions of dollars to relinquish it.
Wow. Well, thank you. Wow, it sounds like you can really save some people there. I'm going to throw this now to everyone, but probably kind of initially to Thomas and Layton, in terms of kind of this kind of a question with respect to, best practices. What are best practices for, and we're switching gears a little bit here, and thank you for allowing me to jump around. We'll take them as they come. Best practices for persuading an early entrepreneurial founder to relinquish control if they're not a great choice or manager for the company's future growth. Happens a lot.
Layton, you want to take first stab, or I can just throw in?
Yeah, I mean, this is back to, do you have some kind of an agreement, owner's agreement, shareholders agreement, or an operating agreement, or partnership agreement, something that kind of deals with this issue? It's always hard to get anybody to relinquish control or to agree to share control. So it's all back to, what Thomas was saying about having a good team to start with. And this is always a problem. This is, if you see this coming, you're going to have a problem down the road. So it's kind of like you get a good team, make the right concessions, have the right provisions in the governing documents to allow for transition.
And I can pretty much just echo exactly what Layton just said. Avoiding these situations at the outset is probably the best practice, right? Obviously, if you're running into it now, you didn't prepare for it beforehand, you're going to run into trouble, especially if it's not documented properly or the right agreements aren't in place. But I mean, at the end of the day, if you are trying to figure this out, because I've actually run into this a couple of times with some of my clients, where they'll have owning control of, in terms of shares, majority shares, and they'll be running the company. They aren't the right person to do so. They aren't putting in enough work. They aren't doing whatever XYZ, whatever it is. It's about kind of trying to put the company's best foot forward. If everyone wants to continue working together, because ultimately, if the owners are having spats and everyone's fighting, the company's not going to do well, right? Because time that you're spending arguing over this is less time that you can spend on lead generation or research and development, or going out and trying to make partnerships to grow your company, right? So if there's a lot of issues going on, ultimately what you need to do is sit down and talk to this person as a collective group. If there's a couple minority shareholders, that feel that the person in charge isn't the right person, you need to find some kind of common ground, and you're going to need to make concessions on some things and try and put the company as a whole, right, the collective group, in the position where saying, hey, this is the best way to move forward. But unfortunately, if the person is either stubborn or it depends on how they act, whatever it is, whatever reason your reasons are for wanting to have them relinquish control. I mean, it's a tough hill to climb, but what I always try and say is, hey, it's about the company, it's about the collective good moving forward, because if we're still spatting and things aren't good, the company's not going to do well, and ultimately we're not going to be able to do well collectively as a whole. So that's kind of how I've always tried to advise clients on this, because ultimately, if you end up in litigation, I mean, especially at a startup, if you're arguing like
business is bad, not enough money.
It's not good.
This is a situation where I really think LLCs are better than corporations, because you can generally divide a business. So if I think the group is somewhat unstable, an LLC is better, because then you can have two people go this way, two people go that way. It's hard to say who this person is. Is he a money person? Is he a service person? You know, what's his relationship to the company? But you have more flexibility to actually, if it's not working out, to actually give pieces of businesses to various people to have them go their separate way, which might be the only way to amicably settle without going to litigation. If you're all stuffed into a corporation, it's really hard to break it out to give certain people what they want to have them go away.
Point. Very good point. I think I have, I don't know if unless if there's no other commentary on that one, I have one other question for now, and then I want to go to your various takeaways that you want to make sure that, you know, from your prior probes that you really felt were very important that we remember. I mean, it's all important, trust me. We're going to go back to the purse example. So in the purse company example, one of your employees wants to become a part owner. There's a question about would that need to be part of the bylaws as to ownership. So what do you do in that? Jeff and Layton, all for anyone who's seen this particular issue. What are your thoughts?
Well, I guess I'll start. Is this like an employment agreement starting off? I mean, a lot of times you have incentive compensation built into that, so you've kind of already like planned for that, whether it vests and what's the nature of it. I will say that in an LLC structure, you can give people profits interests or carried interests. So it is a way, kind of more of a tax-free basis to bring in a key person who's not putting in money. And so you have some flexibility there. This is always, you know, how to keep key employees and keep them happy, particularly if they're essential, is kind of part of the original business plan. How do you keep capital and services and assets so that you can actually grow your business?
Yeah, I think the question was whether that addition of the employee as an owner would need to be part of the bylaws, and I'm not really sure. I'm not really sure that's an employment law question. It's more of a formation question. I mean, generally speaking, like Layton said, to the extent that an employee is going to be participating in those decisions, the entity will still have all of the obligations to meet its employment law responsibilities as to that employee. A transition from employee to owner is not going to eliminate the need to continue paying that person as an employee, if that's the role that they're continuing to have, even though they have an ownership stake. That would be my quick 2 cents.
Layton,
Clearly it's not in the governing documents. If you give them a certain type of equity, it maybe would have to be in the articles, would have to be in the operating agreement or something, depending on what kind of equity you're going to give the person. And normally if he's working for a corporation, it doesn't matter that he's also a shareholder.
Okay. All right. Let's see. Got an IP, opinions about pros and cons of entrepreneurs using LegalZoom for IP issues. Is this one where you say really they should contact an attorney, or maybe I shouldn't say that. It really depends.
So I don't want to single out any third-party platform. I think there are several in addition to that one that people have used and continue to use. What I will say is do your homework and see what services they're providing, because it matters what is and is not included. So for instance, if you're launching your entire company or you're launching your brand and it turns out you're potentially infringing someone else's trademark, that's a big issue. And so whether or not you get assistance with filing a trademark, that's one thing, but have they looked at the USPTO database? If that's included, that's helpful. Are they also running searches on Google or Bing or what have you to see, okay, maybe they haven't registered, but they're using, and as we said in the US, use matters. So again, I don't want to single out any particular company. They have their benefits. If you've got t-shirts, you make up the trademark, it's a strong trademark, you've looked at the USPTO database and there's nothing there. I mean, you could just file it yourself, frankly. I mean, I don't even think you need a benefit of, you'd benefit from using any particular service. But outside of that very narrow situation, it matters because the scope of your protection is all tied to how you describe your goods and services. So the breadth of protection matters. Assignment issues or issues that come up with ownership are huge and in many instances not correctable. So the last thing you want to do is you hire a company, whoever it is, and they file a trademark and it turns out you got it registered in the wrong name and you can't fix it. You've wasted a lot of money, even though you saved money perhaps in the initial filing, you have definitely not gained anything in the long run. So I would say just do your homework and have confidence that whoever you hire has your best interest in mind, is looking into your business needs and is fulfilling them.
No, and that makes absolute sense, and it really, and I agree with you. I mean, everything has a place, and there can be wonderful pros, but across various areas, there can be instances where someone simply doesn't know what they don't know, right. And so it doesn't hurt to also speak with an advisor to make sure that I guess the T's have been crossed and the I's dotted and so forth. Did you want to, and this is really more about you all, I don't know if anyone wants to jump in with specific takeaways that they want to make sure that we hear, because we're kind of more on the home stretch. Layton, I know you had a number of takeaways with respect to LLCs and C Corps that I want to make sure that I get covered before we adjourn. But I know that others, I think, also had some, very interesting, had some conclusions that I wanted to make sure that we covered as well. So I can throw it out to anyone. Thomas?
Sure, yeah, I'll pop in. So my presentation was basically on the intro, just getting started. And so one thing that I trying to instill on my clients and people I've worked with is that ultimately a business is run by people. Okay, like for a fact, like it's run by people. It's run by a group of people, your customers, people. And if it's a big client that you're working with, at the end of the day, the people you're interacting with are people. People are fallible. People make mistakes. People have their own biases. They have their own issues. It is what it is. But at the end of the day, you are trying as a business to grow, either whether you want to have a nonprofit, whether you want to have something that's your passion project, where you want to make some kind of cool product and sell, or a service and sell, or if you want to be in the Web3 space and make NFTs and create art and save the world, whatever it is. At the end of the day, you are working with people, and it's something that you have to remember. And so people are really good, but they can also have separate motives. So it's really important to kind of protect yourselves and protect your company and your idea. Say if you are a founder and you're going to start bringing all these people on, they'll have some kind of talent and they'll be promising you the world, but you have to make sure you protect yourself against that, because people are fallible, things happen. And so it is important to get the right legal entity. It is important to protect your IP. It is important to make sure you are classifying your employees correctly. I have a lot of clients who have run into these issues, especially in the production, the world, being in Los Angeles. you're kind of thrown out. It's a lot of times it's a lot cheaper and easier to just classify someone as an independent contractor, and you can just kind of skirt up, sweep it under the rug, right? But it's just at the end of the day, you got to make sure you're doing everything correctly, because you are working with people and that impacts their livelihoods, and that everyone has their own hopes and dreams. And so just remember that at the end of the day, that you are working with someone else who is here. They have their own path, you have yours, and you're trying to work either collectively, and then ultimately if it becomes a dispute, then you're at odds. But at the end of the day, when you're always gonna be on one side of the table, and on that other side is the person you have to remember.
No, thank you. I appreciate that. Layton.
So I'm going to summarize my takeaways.
I think that I just want to make sure that everyone's takeaways from the first 4 programs. So everything.
Great. So I really love LLCs. I really don't like corporations. So that is for me. Maybe that's my bias. But for startups, Congress has seen fit to give 100% gain exclusion on stock if it's qualified small business stock. It's just an incredible perk. So if you can meet that rule, that's what people should try to achieve. I think that venture capitalists generally don't like LLCs or taxes partnerships for various reasons, 2 that are really critical. One is that you're taxed on the pass-through income, whether or not the entity gives you any money. So you have the ability to have phantom income. And so I think venture capitalists don't like the possibility of phantom income. I think also that when you have an LLC, you're generally, if you're doing business in multiple states, you're generally getting a K-1, and the venture capitalists then have to file tax returns in all these various states because they happen to own an interest in an LLC. So those reasons are really strong for why a VC wouldn't want to have an LLC. You also have on the corporate side now a pretty low rate, 21% rate, which is pretty low. The biggest problem with C Corps is that they're not very flexible, and you have this potential to have a double level tax where you're not just having the owner pay the tax. So you have to work through to make sure your exit strategy is a stock sale or an IPO or something that's not going to give rise to a double level tax, and then that's not going to somehow adversely affect what you get for the company on exit. So it's kind of a dance, but I know that in our program we concluded if you can be a C Corp and you're going to get venture capital, that's probably the way to go. It's a question about whether you want to first start off being an LLC because it gives you some flexibility. You get passed on through of certain losses. You have the flexibility to break up the business. You have the ability to have people get basis step up. There's an election if they buy an interest in the entity. So there are lots of advantages. It's just a question about is it too complex to convert, and how would you convert, and would it somehow interfere with the process of getting capital through the various stages of financing? So that's pretty much what we talked about during the course of our 2-hour presentation. And
just an aside, slightly off topic, but are you seeing many people using the R&D deduction for the payroll? We got an increase in that recently. It looks like a great benefit for startups.
I have another R&D. Let me kind of deviate here. There is an issue that is just coming up on needing to capitalize R&D under code section 174. You used to be able to deduct it. That's going to cause people to be unable to qualify various rounds of financing for qualified small business stock because they're going to have too many assets. Because assets were always based on tax basis, and if you have to now capitalize items that are otherwise deductible, you're going to have more assets than you otherwise would. So you're going to have fewer people use the qualified small business stock because they're going to be over the $50 million limit in order to be a qualified small business. I don't know. It's a lot of people take advantage of like the employment retention tax credit and other credits. There's always some, when you have a new benefit, there are always going to be certain people who are going to use it. And so I don't know. I mean, it could benefit. I think the idea is it's supposed to benefit people in the startup area. But I haven't seen it yet.
Okay, well, thank you. And Thomas, I know you're responding regarding LLC in Wyoming, and I think that you-
yes, I mean, it depends on what the business is and what your the goals are. I know a lot of people in cryptocurrency and NFTs and that like not having their identity revealed, and so you don't have to register your name, you don't have to register an address. You can have a registered agent, obviously, but that's not going to be public knowledge. There's several different things in Wyoming. I have a lot of clients that want to register in Wyoming, being in the Web3 space for this specific reason. There's this thing, it's called doxing, right? So a lot of business is transacted over Twitter, especially in the NFT world on Ethereum or something like Solana or some other layer 1 protocol, right? Where you start a business and you want to keep the owners anonymous, right? You don't want to give that information out because it's in their culture, in that kind of Web3 culture. That's just kind of how it is. That's kind of how NFTs rose to prominence. You can be whoever you want to be on the internet, right? And so filing in Wyoming versus filing in Delaware, where you have to kind of register, you have to have information that can potentially become public. Wyoming can be beneficial to be incorporated in, or your formation of your LLC based on those lack of reporting requirements for your identities.
We have the Corporate Transparency Act now. They just came out with final regs. I know that the Beverly Hills Bar has a course on it. I think it's November 8th, where they're going to go through all the issues where you're supposed to, if you're a smaller company, you're going to have to identify all the beneficial owners and the company applicants as well. So serious crackdown on undisclosed ownership.
Seriously, when does that become effective? Is it 23 or 24?
24.
Okay. No, that's important. And Jeff, I'm going to call you out because in addition to wanting to get your takeaways, we've got a question of interns. How do you deal with interns?
Yeah, so as a general matter, it's going to be most prudent to err on the side of treating them as employees. It is possible to have internships that are not employees. In that situation, the internship needs to be primarily for the benefit of the intern. So this is a way to kind of help train them, give them support. But if you've got unpaid people coming in and really taking the place of people who you ordinarily would pay, doing the same kind of work, and really the business is getting the primary benefit from it, you've got a potential lawsuit on your hands there. It's great to be magnanimous and provide these opportunities. Just do so with the understanding that you're giving something to that intern. You're not necessarily getting something, and definitely seek out the advice of employment counsel before proceeding with an arrangement like that. If you have any questions, so yeah. And I guess takeaway, did you want me to segue to that? I mean, you know, I did this presentation together with Lynn Hook, who was outstanding. And I would suggest that if anyone wants to take a closer look at our materials, it's linked to on the documents, the Google documents that were provided today. We went over just some real core categories of things that employers really should be aware of. I would say some takeaways I would emphasize are: be aware of your wage and hour commitments. Be aware of what you need to provide in terms of meal and rest breaks, how you need to keep track and record hours that are worked, when employees start work and stop work, what kinds of record keeping requirements you have, what kinds of, how you're going to calculate the regular rate of pay for the purpose of paying overtime. Just be aware of what these commitments are, because it's so easy to make an expensive mistake if you don't do it the right way from the beginning. As a second sort of category of takeaway, it's important, I think, also to be aware of the obligations, like I mentioned earlier, when it comes to harassment prevention, when it comes to treating people in a fair way in the workplace, and being respectful. California requires, if a business has more 5 employees or more, California requires sexual harassment prevention training every 2 years. And that includes other kinds of harassment prevention training as well. So it's important to not downplay how significant that can be to your company. As a third general kind of thing to keep track of, your internal practices in terms of record keeping, and this overlaps between wage and hour issues and potential discrimination issues. If you have a personnel file, you want to make sure that you obviously keep good records, but you also want to make sure that that personnel file segregates confidential information, or segregates information that might identify a person's medical condition or national origin, or other information that might put that employee into a protected category. So as you're starting up, it might be tempting to just put everything for an employee into a file, but be cautious about that. Make sure that you know who has access to it, and make sure that if there is confidential information, you know, that it's treated in a manner. Be ready for I-9 audits potentially. You know, when you have that I-9 documentation, that has to be treated carefully as well, but also available in case you need to have an audit. These are just, again, in the category of record keeping, things as a takeaway to be aware of. Be aware of paid sick leave requirements that California has. If you're going to have employees, the employees are going to be entitled to paid sick leave, and there's a requirement in California. And a lot of municipalities and cities have their own separate requirements that also need to be met. So as a business starting up in a place like San Francisco or Los Angeles, make sure that you're aware not only of what the California requirements are, but also what the local jurisdictional requirements might be as to things like paid sick leave, or what they call ban the box issues, where you might ask applicants about their criminal background. There are specific requirements. And so by way of overview, there's more details on the presentation that Lynn and I gave. You're welcome to find it on the BHBA YouTube channel. I believe it's there. Consult with Employment Counsel, and best wishes in your new business.
Excellent, excellent. I have 2 final questions that I'm hoping that we can address, and then I want to let Jonathan kind of conclude this with his takeaways, and appreciate that. One has to do, I guess, actually, one has to do with also going back to the work for hire agreement. Are presumed to be an employee, and if so, can you expressly state they're an independent contractor in addition to assigning the copyright? So I'm looking to Jonathan and to Jeff, and these are interesting questions with respect to, you know, can people self-classify and so forth. So you could look at that, respond to that one. And so they're asking about an independent contractor agreement. So.
Sure. I've never seen that, so I'll defer to Jeff on that regard. My sense is the company would not want to classify them as an independent contractor if they're trying to keep the copyright, because the company that the entrepreneur is part of should be the owner and register with the Copyright Office. So not sure that that directly answers the question, but in most cases, or at least in every case I can think of, the company should own the IP. The company should own at least the copyright and certainly the trademarks there. So, and I'm happy to schedule a time offline to go over kind of the nuances of that in more detail. But I know we're running out of time here too as well. So I'll give I'll pause for Jeff if you wanted to chime in.
Yeah, so this is one of those types of agreements where, depending on how it's worded, depending on the language, it's possible that an employer might get themselves into trouble where they're attempting to have an independent contractor relationship, and then there's some language in there which might suggest that, contrary to the purported independent contractor agreement, you've got an employee here. So that's what I was referring to earlier, where the language, it's important to look at the specific language and then talk probably with IP and as well as with an employment attorney to see if that language is going to get in the way of the party's effort to maintain an independent contractor relationship. I don't know if I mean I don't know if I can give a whole lot more specific answer to that. It's just more of a cautionary comment that, yeah, I mean, this is a potential pitfall.
Thank you. And before I go to Jonathan, Layton, you must hear this all the time. At what point should a startup client work with a tax attorney versus, for instance, their CPA or business attorney?
Well, I think that tax attorneys and CPAs should work closely together. And I think that really it's the CPA that I'd be telling the client that you really ought to get somebody else involved. That to me is really ought to work. Keep that fundamental relationship with the CPA, kind of the day-to-day. And then when you have something that's, kind of out of the ordinary, that's when they refer you on. But again, always sooner better than later, because a little bit goes a long way. A little bit. Yeah, it really has to do with how much advice they're already getting from the CPA or even someone in-house that can kind of stir them along. But I would say in the first year, in the first month, I mean, really if you start getting revenue, all it takes is a quick phone call and you can get a lot of information, very, very useful information very quickly.
Thank you. And Jonathan, what are your takeaways?
Terrific. And I'm almost conflicted here because if I give the whole summary in 2 minutes, then no one's going to watch the video, but that's fine. Time is short, so we'll be very quick on this. Okay. So really 2 points, and they focus on 2 aspects, trademarks and copyrights. Trademarks, what are they? Words, symbols, devices in combination that identify the source of one's goods or services. We want to select brands that are protectable and registrable. What that means is don't pick marks that are generic. So escalator is something that's now in the public domain. Quick print for printing services, it describes the product or service immediately. We want to avoid those at all costs because if you're using it, your competitors can use it, everyone can use it, there's no brand. So try to pick a mark that's stronger. I don't care if you forget the names, suggestive, arbitrary, fanciful, that doesn't matter. If there's a disconnect between the trademark and your underlying product or service, so if you think of Apple for computers, there's no relationship between those products. That's a very strong trademark. Registering is very important because it gives you the benefit of it's presumed that you own it, it's valid, you've used in all 50 states, even if you haven't, if you've used it in just 2 states, it doesn't matter. The trademark office presumes that you've used everywhere, which is great for sending cease and desist letters. And then once you have it, you have to protect it. You can't just register it and then let a number of third parties use it without sending a letter or contacting them. There are ways that I talk about in the video to help with enforcement that doesn't require you to go out and sue right away. So I'd say those are things to watch out for, is make sure that once you have a trademark, you protect it and don't let other people use it in a generic or descriptive manner. That's trademarks. Copyrights. What is it? It's books, movies, websites, text, images that are fixed in a tangible medium of expression. That just means that someone takes a photograph with their smartphone, it's now fixed in their phone. They own the copyright in that. Work for hire, which we talked about several times, is important because you want to make sure that if you're not clear if you have an employee situation, just have them sign a document that says, yes, the company owns the copyright and all IP that is necessary for the business in order to have the business register it. The one big difference between trademark and copyrights is trademarks can go on for forever as long as you're using it. Copyrights and patents, however, are of limited duration. So the government does expect this quid pro quo where they'll give you an exclusive right for a set number of years, and then you have to basically give it to the public. The last thing I would say, I know I said 2 points, but I'll just throw in another third one. Domain names. Don't get hung up. I really don't think people should get hung up on matching the domain name to the trademark exactly. If you get .com, great. If you don't freak out about that. I think the way that people are searching websites on smart devices, to tablets and smartphones, they don't really care if it's a .net, .biz, what have you. They just want to know the website. Does it look fancy and does it get me what I need? So select the trademark first. Don't select the domain name first. Hopefully they match, but I wouldn't get too hung up on that. And why not throw in a fourth point? Your LLC does not have to match your brand. And that's actually surprising to a number of people that they say, well, but my LLC in California is this, and I don't want, do I have to change it? The answer is no, you don't. The trademark is completely separate from your underlying corporate name. So if for whatever reason you need to change that or have them different, that's not a problem. This has been an absolute pleasure. Thank you so much, LaVonne, and my co-speakers. This has been a lot of fun. Thank you. Thank you very much.
Well, thank you to you all. This has really been a lot of fun, and I'm so delighted that we could do this, and thank you very much. And people had a number of questions, and I'm glad that the materials are there for the audience. The materials are there. The contact information for the speakers is there, because I think that you will probably want to reach out. From what I can tell from the nature of the questions, you probably may want to reach out to our wonderful speakers if you have like additional questions and so forth. Again, this has been fun. So thank you so much. And thank you to the audience for joining us in this conversation. And I guess that's it for this program. And at least until we do the next program. So have a great afternoon, everyone. Thanks.
Thank you.
Thank you so much.